First, a huge thank you to all of our speakers. This has been really a fantastic conference with the papers all in dialogue with one another and just wonderful. I learned an enormous amount and I was so happy to have all of you here. And then again, another huge shout out to the Academy staff that made this possible. Eliza Wong, Mark Robbins, Julia Bada, there in the back, Tina Cancini. So we've arrived at the end of really a fascinating, if a bit disturbing, journey through identity and citizenship. Its multivalence and changing meanings, its impact on those who have it and those who don't. I think we would all agree that this has been an exceedingly fruitful series of presentations, incredibly thought-provoking, and a particularly, I'm using that word again, Fiore, generative comparative dialogue. And I think it's a comparison that we don't see often between the United States and Italy, and I think there's a lot of useful comparisons here. So taken together, the presentations pulled out a series of themes that shape our understanding of citizenship over time. How to define it, who defines it, how different historical moments and places define it based on conditions on the ground, that techniques used to keep certain races, genders, and ethnicities in or out of the condition of full citizenship. And we've seen again and again in the presentations the fragility and precarity of the title citizen. This precarity is a through line really in all of modern history globally. One need think only of the stateless Jews of the Nazi and World War II period, or of the Vietnamese and Cambodian refugees in the wake of American defeats in Vietnam, or today the situation of Afghans trying to get out of Taliban-run Afghanistan, Afghan refugees in camps outside of Afghanistan, and we can cite many, many more situations like this. Now, when I put this conference together, I decided not to give a paper. My own academic work, as many of you know, is a bit far afield. And I didn't think I had anything to say about all this, but as I'm sitting here, I realize that I actually do have a bit to say, and Michael Vorenberg has consented me a bit of his time, or we'll just go a little bit over. But I realized that my non-academic life, about which some of you here know, has been deeply intertwined with the politics of migration and detention. I have been involved in the civil rights struggle, both sort of at the macro level through the organization of the ACLU, which I would like to do a shout out. The California ACLU were the ones that brought an end to the child separation policy at the border. And then also at a micro level. And I'd like to talk a little bit about that micro level and about the reality of migration and detention in the United States. And as Gia Cagliotti said this morning during the question period, citizenship matters most to people trying to move from one place to another looking for safety. Most migration is about just that, and this kind of movement is getting increasingly more dangerous and more urgent as global climate and economic conditions worsen. So I just want to say a few words about the system of migrant detention in the United States based on my own solidarity work. As Fiore just reminded us, solidarity among migrants and with migrants is an essential element of this story. So in 2017, 18, and 19, up until the pandemic, my family and I would go out twice a month. We worked with a small Latino church group sort of east of Los Angeles in a town called Linwood, and we would go out and visit detainees in the private prison, the Geo Group run prison in the high desert. Adelanto, located in the high desert above Los Angeles, and this location is not random. It is about 2.5, almost 3 hours outside of Los Angeles, and it is a place of deep economic deprivation, Even despite the private prison, it's a very depressing place, and it is a place where the only decent job is prison guard. It is run, as I said, by Adelanto, by Geo Group, the private prison company, which makes huge profits, is listed on the New York Stock Exchange. I hate to say many of our pensions may in fact be invested partially with these private prison groups. People should look into that. So the prisoners at Adelanto are divided into two categories. There are the people who are picked up in California and found to not to be undocumented. And then there are the people who are picked up at the crossing the border and sent to Adelanto. Those picked up at the border wear orange jumpsuits, and those picked up arrested in California within the state, undocumented, wear blue jumpsuits. So immediately you feel this is a criminal, this is a penal institution. They are being treated, even though they have not been convicted of a crime, they are being treated as prisoners. Geo Group provides very little food and extremely poor quality food and barely any medical care. This became an emergency during the pandemic. And in order to feed themselves or to get shampoo or to get laundry detergent, you have to buy this at the commissary. And anything at the commissary is extremely inflated. Like a Snickers bar is $3. Now, how do you get the money to buy that Snickers bar or that shampoo or that hand sanitizer that became, as we all know, extremely important? You get that money when your relatives come to visit you and they put it in this bank machine that takes 20% of your money, and that 20% goes to Geo Group and 80% go to the detainee. So the profit is being made in all directions, and the state pays per day per prisoner an enormous amount to Geo Group. So it's nearly impossible to get into these detention centers, no surprise, and the only way you can get in is if you have the name of someone in there. Well, how do you get the name of someone in there? So this church group got the word out that people could write to them. It's very hard to make a phone call, but people would write the church group, and then the church would show up with a list of names, and so they'd give us a name, and I'm using an anonymous name, but I'd go to the desk and say, I'm here to see Maria Sanchez, and then they would frisk me, literally, and I'd have to put everything in a locker. I couldn't even bring a pencil or a piece of paper in, and then for an hour, you could sit in a plastic chair across from a detainee and hear their story and try to memorize a relative's phone number. This is the United States, like 2 years ago. It's since been closed. I am happy to say that. So the first time I went, I met a man from Nigeria. I talked to him for an hour. He was a gay man from Nigeria. He owned a small store. He sold everything he had. His family gave them everything they had. He bought a one-way ticket to Brazil. He landed in Brazil. They gave him 48 hours to get out of Brazil. But at that point, he had no money. He walked from Brazil to the US-Mexico border, was picked up at the border, sent to Adelanto. He'd been there 16 months when I met him. He was having terrible health problems and not getting any medical care. He did eventually get a lawyer and get out. The second time I met a 5-year-old girl who was there with an aunt visiting her mother. Her mother had gone to an office party. The mother had come to the United States when she was 6 and had gone to college and had this office job and had gone to an office party and had a couple drinks and was driving around and was pulled over and given a DUI and sent to Adelanto. And she had been at that point 6 months in immigrant detention, seeing her 6-year-old girl occasionally. So this is what Adelanto looks like from the outside. These are some of the images. These are the Texas holding centers. This is not what it looks like inside once people have been moved from the border to the interior. But I'd like to say a little bit, particularly for Italians who may not know as much about this, conditions on the ground, particularly at the ICE and Customs and Border Patrol holding centers. So as of summer 2019, The Department of Health and Human Services held more than 12,000 minors and an average of 52,000 people per day in migrant detention in a variety of places. Here's the map showing you. So you see that you can see the private prisons, you can see some of the county and city facilities and the border facilities on that map. 70% of people are held in private detention, for-profit prisons. 26 adults died in U.S. detention in 2019, and 6 children in the first few months of 2019. The Trump administration refugee refusal policy depended on deliberate cruelty, on overcrowding, this is what we see here, on sleep and food deprivation, on denial of medical care, and on the physical and sexual abuse of adults and children. You know, the idea here was that this would be deterrence, and it's come out fairly recently that at some of these detention centers in Texas, there was a gynecologist who was sterilizing women. When they'd ask for an appointment with a gynecologist, if they'd gotten an infection or something, he would take that opportunity to sterilize them. There's a record of 50. It's still under investigation, but you know, the resonances of that are terrifying. At the processing center in El Paso, Texas, for example, in July 2019, 900 migrants were held in a facility designed for 125 people. In some cases, cells designed for 35 were holding 155 people. And as of that month, there were 200 migrant jails and prisons on American soil. Among the most notorious of the human rights abuses used in these in immigrant detention was the purposely placing of detainees in empty, chilled rooms where they sat on the floor, and that's what the Mylar blankets are. So they would call these, literally these rooms, refrigerators, and when they would keep them very, very cold. As Human Rights Watch observed, United States immigration authorities routinely detain men, women, and children, including infants, in frigid holding cells, sometimes for days. Migrants and U.S. Customs and Border Protection agents alike commonly refer to these cells as my Spanish is terrible, hileras, is that right? Or freezers. The few observers allowed inside reported adults and children locked inside chain link fences, as we see, overcrowded bunk rooms, the Mylar blankets on cold concrete floors. At one Border Patrol station, again in Texas, we keep coming back to Texas, I'm sorry about that, but it's happening in Arizona and New Mexico as well. They found children under the age of 11 fending for themselves, caring for infants and toddlers, and this Human Rights Watch delegation also saw, quote, visibly dirty, mucus, mud-stained, and nearly all wearing the same clothes they'd worn when they crossed the border. The children told them they were not given regular access to soap or toothbrushes, and they were only given showers once in the period of a number of weeks. All of this, I guess, to say that we need to be reminded of the on-the-ground conditions, and also that this treatment in the U.S. reminds us that those most endangered by the boundaries of citizenship are the migrants, those seeking new citizenship, but they're left in most cases in a dangerous liminal state. So thank you for letting me throw that in, and now I would be very honored to introduce Michael Vorenberg, our closing keynote speaker. Does anyone have 1 or 2 questions on the detention issue before we turn it over to history? Okay, we can also talk about it at the end. So Michael Vorenberg is our, we're going to switch out the PowerPoint, is our closing keynote speaker, and he's going to present a lecture entitled Reconstruction as Risorgimento, the Creation and Limits of U.S. National Citizenship in the 19th Century. Professor Vorenberg is professor of history at Brown University. He is the author of a number of extremely impactful books that have reached far beyond their historical subfield, books which force us to think about the how and why of contemporary American political culture, why it looks the way it does. In 2001, he published Final Freedom, The Civil War, the Abolition of Slavery, and the 13th Amendment. This book was a finalist for the Lincoln Prize, and really quite excitingly was also the basis for much of the script of Steven Spielberg's 2012 film Lincoln. Professor Vorenberg is also the author of The Emancipation Proclamation, A Brief History of Documents from Bedford St. Martin's in 2010. And then he has forthcoming next year with Alfred Knopf, a big book entitled Lincoln's Peace, The Struggle to Find the End of the American Civil War. And I learned from Professor Vorenberg that it took a long time to actually end the American Civil War. On questions of, Professor Vorenberg has written an extraordinary number of articles on the Civil War, on Lincoln, and on American political culture. And on questions of citizenship, he's also published extensively. For example, an article from 2011 entitled Liberté, Égalité, and Lincoln. From 2010, Citizenship and the 13th Amendment. And from 2009, Abraham Lincoln's Fellow Citizens Before and After Emancipation. He is the recipient of many honors and fellowships, including from the American Council of Learned Societies and from the National Endowment for the Humanities. And then his most important one was in 2018 and 2019, he was the Billington Professor at Occidental College and the Huntington Library, and he was an absolutely wonderful colleague and a madly popular professor, and anytime he wants to come back, the desk is there. Professor Vorenberg is also a public intellectual and is working to use the past to improve the present, and really working on what I see as America's fatal flaw, which is our gun culture. And in the wake of the June 2022 Supreme Court firearms decision, known as the Bruin decision, that required every firearms law to be justified with a historical precedent, Professor Vorenberg was hired by a number of states as an expert to testify in order to make sure that existing and future gun restrictions would hold up under this law. And he's currently involved in federal court lawsuits trying to overturn gun laws in California, Illinois, Massachusetts, Oregon, and Rhode Island. And Rhode Island, which is his home state, is the first and only state so far to actually get a ruling on a challenge, and that challenge is on banning assault rifles has been held up. Now, also quite interestingly, Professor Vorenberg is the two-time winner of the New Yorker Cartoon Caption Contest. So on a lighter note, maybe you will send us those cartoons that you caption. But it is a great pleasure to welcome Professor Vorenberg to the podium.
Thank you, Marla, for that. That was a very generous introduction. There is simply no way I can connect the New Yorker piece to the stuff I've been doing around firearms legislation. And again, just to be clear on that, so you know where I am on the side of protecting the legislation, not the guns. And if any of you want to ask me about that, I'm happy to talk about that. And because it is a pressing issue, one of the things the United States is, of course, known for greatly is its proliferation of guns. It's something I may be able to mention today too in this talk. And it deeply involves history and the way Americans think about how to use history in making law today, which is also distinctive and also done quite badly. And so something worth talking about. Maybe not here, but maybe in the reception. I'm going to say, first of all, a few words of thanks, as others have said, to the American Academy in Rome for hosting the conference, and to Marla especially, to convening the conference and having me here. This has been fantastic. I have learned so much, and things I just never knew. I also appreciate the great logistical assistance from Julia Bada. And so I am the last presenter, and I'm keenly aware of the many things that means, most important of which, I am all that stands between you and the drinks, and which are really the only thing that hold a community together in the end. And so I will do my best not to abuse that privilege. I will also note that although the title of my talk has Risorgimento in it, I need to be very clear right up front, and this would become obvious rather soon, that I am not an Italianist by any means. I am not a historian of Italy. So, however, as a historian of the United States who specializes in Reconstruction, that is especially the period after the Civil War, I have long been aware of not just the parallels, but the connections at the time between Italy and Risorgimento and the United States and Reconstruction. Risorgimento ends when Reconstruction begins, quite literally, 1861. And if you want to focus on dates. And I'm taking us now back farther in the past than most of us have gone, which may seem strange for the last speaker. But what I'm trying to do is to essentially say, how did we get here? And from the American perspective. And I will at the end touch on issues that are very much at present and that were brought up yesterday by John Torpy about what is about to happen in American law around the issue of race, as it concerns the US Supreme Court. Not that I can tell you what's going to happen, but what I think is very likely to happen around issues of race in education, in voting rights, and other matters where major decisions have already been handed down, but the most major decision of all will be handed down this coming spring and then in the years to follow. I think we can be assured of that. So I want to begin this talk actually right where Sabina Donati ended. And in fact, she was kind enough to let me steal her last slide, which I had never, well, I've read Dante many years ago in English, and I must have read this phrase, but I've never come back to it, and I was quite struck when I saw this. And I want to now, as I said, steal it in the kindest of ways, in a slightly different way, because it ends with this issue, your talk ended with this question of, would it be worse for man on earth if he were not a citizen? And I want us all to ask ourselves that question in light of the things we've heard these last 2 days. If citizenship is, and I believe it is, a troubling category that involves exclusion, if not inclusion, and the two are constitutive, if it is about borders, and not just geographic borders, but as the historian Barbara Welke has written, about all kinds of borders. In the United States, as I'll talk about today, the most important border is the border between racialized slavery and freedom, which was figured as white in the pre-Civil War period, and for many even after. If citizenship is such a troubling category, what do we lose if we abandon citizenship? Is it so bad if we lose the category of citizenship? And then necessarily we would then have to come up with some kind of replacement. And what would that be? So I hope I'm going to cut big pieces out of what I was going to say for the purpose of, again, the reception. But also that maybe I think it might be nice to hear from you all and have you hear from each other what you think about that question, because it's been looming over all of us, I think. And so I would like, and I'm curious about what you all think. I'm going to quickly now turn to two images that try to directly connect Risorgimento and Reconstruction. And this is the Italian image. Again, the artist is not particularly famous. This is Garibaldi entering Pavia, and the scene is from 1849, the painting from 1862. It's the date of the painting matters more to me than the date of the scene, because 1862, of course, is the year after Victor Emmanuel, is the king, pronounces the end of Risorgimento in Parliament as well, and but also for the Civil War, it's terribly important for all sorts of reasons. The year, it's 1 year into the war. This is the year when Lincoln will issue the first Emancipation Proclamation. I could go on and on. But here we have Garibaldi entering a city and liberating the city. And you can barely see Garibaldi. And you really have to get close and look hard. And that's part of, I think, the story. I think there is a nostalgia to this that many in the room could speak to better than I. This idea of the humility of Garibaldi, and that makes him a kind of fellow citizen to the people who champion the liberation of this. And the commonality, the fraternità, I'm sorry for my pronunciation, of all that are there. And that being so important to the idea of Risorgimento, that the enemies have been conquered. Of course, that then allows you to erase what was really going on in Northeast Italy, where certain cities were still under Austria control. It allows you to ignore the so-called Southern problem. And of course, in the United States, they were having their own Southern problem, still do. And this idea also that the Pope really wasn't to be feared anymore. One thing I'm struck by in this painting is that the priest, I believe he's a cleric, is making his way as quickly as his feet pointed out to sort of, he's scared by the whole scene, and he's departing, right, stage left. And now I jump to a very similar scene. I was struck by the similarity of this. The liberation, if you will, of Richmond, Virginia in 1865. And Lincoln, so Richmond, Virginia, for those you don't know, it's the capital of Virginia, and it was the capital of the Confederacy, the Confederate States of America, the rebellious so-called nation. Lincoln always called it a so-called nation. It, of course, claimed itself to be a nation. It was a slave-holding republic based on white supremacy and the idea that slavery was the best form of labor there was. It was not a nation, to my mind, but it called itself a nation, and Richmond was its capital. And it falls on April 4, 1865, April 3rd, and April 4, the next day, Lincoln happens to be he knows exactly what's going on. And he's nearby and he visits Richmond, and he brings his son, you'll see that, it's not there in that picture, to go through Richmond. And what you see here again is this scene of liberation, someone holding up their child, like this idea of the humility of the man among the people. And one of the things that strikes me about this image is that the real scene in Richmond that Lincoln faces is really composed of two major populations. A small population of white people who really despise him. And so he actually has to have bodyguards around him. And yet what you see here, so far as I can tell, is mostly white people who are in celebration, except perhaps the woman up on the left, who I think we're supposed to believe is a Confederate widow, who is not so sure. And this would be the classic Confederate widow who might put up a fuss if forced to take an oath of loyalty, which they would have to take in order to regain their citizenship as United States citizens, which would mean all sorts of things for them, including being able to provide food, because without that, the army would not provide rations to them that they desperately needed. But the whitewashing is what's clear, right? That there are almost no black people in this scene, except for the driver, right? That's the most visible black person, the driver of the cart. Now, this is quite striking. Now, there are African Americans elsewhere, right? So this is a young African-American woman who's reaching out to him, and another one. And here again, there's an African-American at center. But I'm just struck by the presence, that they are a minimal presence. Now, Thomas Nast, famous American artist for Harper's Weekly, his sketch is much more accurate and to the point. Richmond is destroyed by this point, and Lincoln is surrounded by black folk who want to celebrate him. There is something problematic with this as well, of course. They are bowing down to him. And this comes from a story, almost certainly untrue, that while he walked through Richmond, that the first person to see him was a black man who came to him and got on his knees and bowed down to him. And Lincoln then said, "Stand, you are free, you should bow to no person." And almost certainly this was complete fiction, and it buys into this notion of Lincoln, the liberator. I want to just say, though, and the sketch buys into that scene. But here you see the double story of liberation. Liberation of a city, liberation of a people, where Lincoln is figured as the liberator and the people themselves are being liberated. This being a big problem in the way Americans think about emancipation. And yet, as I said, when we come back to this, that particular dynamic around emancipation is lost. So, were the black people in Richmond that day citizens? Were they free people? Were they still slaves? And the answer to all those questions is yes. They were, by certain definitions, one or the other, or all three. Citizenship was, at this time, an incredibly elastic and constricting category. It was both. It was functionalist to serve the interests of the state, which is a generous term for the party in control, and it had evolved quickly over time, defined differently by different people, and simply unimaginable to be debated, if not for the presence of racialized chattel slavery in the United States far longer than it existed in any other republic, the only other two where it exists in the Western Hemisphere still, Brazil and Cuba, where the transition to formal legal citizenship would take much longer, whereas in the United States, the Civil War begins in 1861. By 1868, only 7 years later, the 14th Amendment has been ratified, and I'll say more about that because that is the amendment that establishes in the Constitution this principle of birthright citizenship, which is birthright citizenship for all. In 1862, 6 years earlier, the Attorney General of the United States, Edward Bates, had written an official opinion, which I can say more about if you want, which officially established birthright citizenship, but only for free people, free-born people. We have to be always careful with our terminology. Many of you have said ius soli here and ius sanguinis. These are words I have to read and write all the time. I've never been among so many people who use these terms. It's been fantastic. And so I don't have to explain what they mean. In fact, you probably can tell me more than I know. But with birthright, right? In America, in the United States, it's so important that born free was established as a citizen in 1862 by opinion. And when Bates was pressed, well, what about if someone who was born a slave? He said, I cannot answer that question. And so it's not until 6 years later with the ratification of the 14th Amendment where whether you're freeborn or slave-born doesn't matter, is that finally dealt with. And in that opinion written by Edward Bates, he spent months trying to figure out the answer to this question of citizenship. 5 years earlier, the Supreme Court had ruled that no black American was a citizen. This is the famous Dred Scott opinion. And to do that, I'll say more about that too, they went back to history and invented a history whereby as the interpretation said it, black people never had rights that white people need respect. That was a description by the court of how things were at the time the US Constitution was written. And therefore, since it was the case then, it must be the case now. Now, that is a fiction, because in fact, in many places, black people had plenty of rights, including equal rights, certainly in the Northeast. Even some had voting rights. But that fiction, the legal fiction that the court uses, says, well, therefore, since there were no rights, they were not citizens. So it does a couple things. It erases and distorts history, but it also fuses citizenship with rights, as if rights is the only thing that matter for citizenship. And certainly rights are important for citizenship, but there are other meanings to citizenship. Anyway, Bates was trying to work this out 5 years after the Dred Scott case, and he writes to his friend, Francis Lieber. Lieber is a German-born scholar, and certainly the most respected political scientist of the day, and a friend of Edward Bates. And Lieber was very versed in what citizenship and nationhood meant in Europe. And Bates writes to Lieber that he was really now distraught, that he had taken on this, what he calls this impossible task, to give a precise definition of citizen. This is in 1862. And he says, 80 years of practical enjoyment of citizenship under the Constitution. 80 years is the number of years since the US Constitution was ratified, okay? 80 years of enjoyment of citizenship have not sufficed to teach us either the exact meaning of the word or the constituent elements of the thing, citizenship, we prize so highly. In other words, I'm the Attorney General of the United States, I'm the highest ranking legal officer of the United States, and I don't know what citizenship is, and I don't know how to find out. And that confusion, well, confusion is a kind word, we then say, okay, that's a lawmaker. What about ordinary people? And so here I'm now going to jump over what I was going to speak, so I can jump to some data, if you will, because I think you'll find this interesting. So years ago, I set out to write a book about citizenship, and then I got sidetracked with this book about the end of the Civil War, and wrote some pieces about citizenship, and I'll come back and write more about that. But I did a large amount of archival research, trying to figure out the answer to the following question. How did ordinary people, regardless of color, regardless of gender, and so forth, on the ground during this time, what did they think about citizenship? And the answer, I think, when the war broke out, is simply they weren't thinking about citizenship that much. And I think this is a very common story, that were it not for certain crises, whether it be a war, or not necessarily a crisis, but transformation, emancipation, or border crossings, were it not for these kinds of societal upheavals, citizenship would not necessarily be that important. Now, one of the things that I went through to discover this was the following. During the Civil War, the United States sets up a blockade of the South. And the idea of this blockade is ships on the ocean to capture anyone trying to smuggle goods to the South. And this is done in wartime. So what the ships do is they stop any ship from anywhere, from any country, and they search it. But the important thing to me is they take all the sailors aboard and they depose them. That is, they interview them, and they ask a series of questions. And these questions are the standing interrogatories. They are the standing questions that they ask everyone. And those questions are as follows. And I'm just going to try to skip ahead here. Okay. So the idea is that you bring sailors into court, and then you ask them a series of questions. We have, I amassed close to 500-600 of these answers to these questions. These are ordinary sailors from around the Atlantic. Now they're sailors by profession, which means they're not spending a lot of time in one place. That is important and perhaps relevant. The questions they ask are the following. Where were you born? Born. So we have birth, right? Io soli. Where do you live? Now that's a tricky one for a sailor. But what place do you call home, domicile, habitant? Of what country are you a citizen? To whom do you owe allegiance? Now notice how these two questions are separated. Of what country are you a citizen, and to whom do you owe allegiance? We would say, well, that's the same question. No, they separate them. And question 5, are you married? And if, these are all men. And if so, where do your wife and family reside? Why that, right? And this, again, speaks to something that all of us have been, many of you have been talking about, the gender and familial quality of citizenship. Prove to me you're a citizen. Tell me where your family is. Show me that you have a family, that these count towards citizenship. So I'm now going to run through a bunch of slides that I'm not showing to get to the ones I want to show. I have so many spreadsheets that look like this you can't read. Let me get close. I think you might be able to read that. I really hope so. So let me start with some sailors who are from Europe, but not Italy. And these are some of the answers they give to these questions. And the stuff on the left is the date, the name of the sailor, the name of the ship. And you get the point of all this, I'll just say right up front, is just when you get people in front of you and you ask them these questions, they're all over the place. There is no consistency about this. In other words, they haven't been forced to think about these things until this moment where they're brought before some kind of court that could end up imprisoning them if they are in fact aiding the Confederacy and if they are in fact Confederates themselves. So I picked somebody from Germany, I picked somebody from Finland, somebody from England. And like the person in Finland, I was born in Finland. I now live in New Orleans. This is the second one. I've lived there since I came to this country, which was about 3 years ago. I am a subject of the Russian government and owe allegiance there too. So you have all these different places, born one place, citizen of another, subject to the Russian government. I am not a married man. And then the English person, I'm a subject of the Queen of Great Britain. Now, I could go on, but I want to jump to the Italians because I'm sure you'd be interested in what they said. And I have a bunch, but I'll just show you a few. So these are people who have some kind of connection, not necessarily to Italy, right? I was born in Italy. I'm 13 years old. I now live in Boston. I've lived there for 3 years past. I don't know to whom I owe allegiance. I was born in Trieste. That's kind of handy since we just heard about Trieste. I now live in Havana. And I've lived there 2 years. I owe allegiance to the Empire of Austria. So goes the Risorgimento. And I am married. My family live in Trieste. Born in Senigallia in Rome. Now lives in Charleston, South Carolina. I am a subject to Victor Emmanuel, King of Italy. I owe allegiance to him. I am not a citizen of the United States. I was born in Venice. I am a seaman and have no fixed place of residence. I am a citizen of Italy. I am a citizen of Italy and owe allegiance to Emperor of Austria. Now, how can that be? Right? So these simply make no sense. Unless, of course, you come at it as a historian and say, of course, it makes all the sense in the world, because they live their day-to-day lives without having to think about these things. Bless you. Some American-born people, North and South. Because one of the things that happens during the Civil War is that you've got people going back and forth, and the war breaks out, and a border is established between North and South, right? And I'll just, I don't want to spend too much of this, but you can read around this. I was born in a northern county in the state of Virginia. I have no fixed place of residence now. I'm a citizen of the United States of America, born in Virginia, which is in the Confederacy, but I'm a citizen of the United States. So that's about volitional allegiance, this idea that you choose to belong to live in the US. I was born in the state of Rhode Island. I wasn't born there, but I lived there for many years. I now live in South Carolina. I am married, and my family reside there. I've lived there for 27 years. I'm a citizen of the United States. You've lived in South Carolina for 27 years, and you're a citizen of the United States, not the Confederate States, really? I have never taken an oath of allegiance to the Confederate States. That's the key. No oath, therefore no citizenship. And I do not know whom I pledge allegiance. I do not know who I pledge allegiance. I can't answer that question. A number of these sailors are black. Some born in Europe, many born in the United States. They are identified as black by all the people taking the depositions. Actually, they are identified as colored. So now I add some of them. You can see that they're, this is my transcription marking them as colored. Colored seamen, seamen colored, and where they are born. And this is someone born in the West Indies, now lives in New York, and lived there for 6 years. I am a citizen of the United States of America and owe allegiance to that forever. Now this is great, because this is in 1861. Dred Scott decision is 4 years old. The law of the land is that this person cannot be a citizen. He also wasn't born in the United States. He was born in Caracal, and so he has no claim to citizenship except his own. And that claim matters to him. I am a citizen and will be forever. Those claims of citizenship, people of color have been making in the United States going back to the Revolution and before. Martha S. Jones's book called Birthright Citizenship does this beautifully, as she discovered 10 years ago this cache of documents in a Baltimore courthouse. Baltimore in Maryland, a slave state. And here are all these African Americans, many of them free, but some whose status is not clear. That is, they could be categorized as slave, who go to court, claim citizenship on the basis of birth or this military service of their forebears. And on that claim, they then say, I'm a citizen, therefore I have rights. Again, this inverts what the Dred Scott decision said, which is you have no rights, therefore you cannot be a citizen. And so these sorts of claims are being made. I now want to just speak for a second about the last one, Charles Hall. I was born in Fairfax County, that's in northern, depends on how you categorize Virginia, in Virginia, but that's not too far from Washington, D.C. I now live in Washington, D.C., and I've lived there for 5 years. I owe allegiance to the northern country. I belong to the United States. I'm a married man, and my wife and family reside in Ohio. I live in Washington, my wife and child are in Ohio. How does that work? I must be a citizen of the United States of America if I am a citizen of all. This is my favorite of all of these. In other words, I have to be a citizen of somewhere. And I guess if I have to be a citizen of somewhere, it has to be the United States. So that's one piece. But the phrase I want to focus on actually comes before that. I belong to the United States. I mentioned the historian Barbara Welke wrote this wonderful book called Borders and Belonging, which is about American citizenship. Belong is a word that has, of course, this powerful double meaning to a person like Charles Hall, because belong has a meaning about the enslaved, that is, to the enslaver. This incredibly quick transition from belonging to a person to belonging to a citizenry, that makes the United States experience, I think, distinctive, perhaps from most places, maybe all, and certainly the defining distinction between the United States and Italy, as I see it, in terms of the crucial quality of what it means to have racialized enslaved people be free by their own dint of action and claim, and to some extent by what the state has done. And now the word belong has been transformed by the person who responds to those interrogations. Citizenship is about both things, really, if you think about it. It is about longing. That is, in the 19th century, it has this quality of romanticism, of the romantic nationalism of the period in Europe and the United States. The longing for a citizenry that is universal, as broad and as inclusive as possible. This was the longing, I would argue, of the great intellectual behind Italian citizenship, Mazzini, who had great connections in the US, who was a powerful voice for anti-slavery, and the person you had to see if you were an American abolitionist going to Italy. you tried to see if you could. This idea of republicanism as transatlantic that Mazzini is pushing, it becomes a bit of a problem when his ally Garibaldi is asked by Abraham Lincoln to command a regiment during the American Civil War. And Lincoln wants this, of course, because, again, the Italian Wars of Unification have gotten so much notice. This idea of republicanism in the Italian unification is what Lincoln wants to draw on for legitimacy of his party, the Republicans. And so he asks Garibaldi, and Mazzini says to Garibaldi, no, I'm sorry, I don't want you to go. We need you here because, of course, our work is not done. And so Garibaldi does not go, although a United States regiment is composed of more than 500 people who were born in Italy, calling themselves the Garibaldi Regiment. But this idea of a kind of universality of citizenship, which is an Enlightenment and post-Enlightenment idea, and so important, is about longing, right? And it has a romantic quality that coincides against belonging, which is, by definition, exclusive, or the word that the political scientists tend to use in America, ascriptive. So whereas we might think of citizenship being descriptive, that is, we shall describe the positive traits or legal qualities or affections that make a person a citizen, ascriptive citizenship says that citizenship is defined by what you are not. And that is a theme that has come up over and over again, I think, in these last 2 days, and highly relevant here. And belonging necessarily is ascriptive, because if one belongs, then one must not. There must be one that does not, if not more. Longing and belonging. Belonging is embodied in the phrase that Lincoln used over and over again in his addresses, where he would address people as my fellow citizens. My fellow citizens. That phrase, I believe he's the first to use it with any kind of regularity, and then it becomes embedded in the rhetoric of American politicians, especially presidents. My fellow citizens. What's the difference between a fellow citizen and a citizen, right? Well, there's no technical difference, but I think you can see where this is going. The fellow citizen is a citizen not merely by law, but by association. That is, someone who we associate with, we associate together. Fellowship, brotherhood, fraternité, fraternitas. All these ideas of association. And the idea of citizenship as an associational quality, not just as a category of rights, but association, is crucial. And going back to the Dred Scott decision in 1857, when the Chief Justice rules against black citizenship, what is the statement that he gives? He says, ultimately, this is quoting from the Chief Justice, Roger Taney, blacks had for more than a century before, that is before 1857, been regarded as altogether unfit to associate with the white race. So he invokes association, saying that because they don't associate, that in itself is proof of non-citizenship. He doesn't rely on this phrase, fellow citizenship. He uses it to deny citizenship entirely. Race obviously is the operative category in that decision, and all these decisions, and all these cases. And now I just want to buzz very quickly to get us to today, and then I promise to stop and take questions, because I think you're going to have a lot. In this quick, I won't rush. I won't buzz too quickly. I am someone who studies law and the American Constitution, especially of this period, quite deeply. And those laws, especially the amendments to the Constitution that are created during this period, continue to be contested, continue to get a great deal of press. For good reason. I'm going to just talk about 3 of them today. And I'm going to talk mostly about these last two, which is ironic because I wrote a book about the first one, the 13th Amendment. The 13th Amendment abolishes slavery. And it is perhaps known better today in the United States and perhaps here as well, not for the fact that it abolished slavery, but for the exception clause. That is the clause that says, except as a punishment for crime whereof the party shall have been duly convicted. In other words, that's what we call the exception clause. That some would say allows servitude, if not slavery, to exist. And if you have questions about that, I can try to answer them. I've been working on that one for more than 25 years. But as many of you know, that clause is usually invoked to explain a lot of things, including the specific racial carceral quality of the American society. And I have more to say about that if you wish. But it was an amendment that was declaratory about abolition. It says neither slavery nor involuntary servitude shall exist. That's terribly important, as opposed to saying states don't have the right to have slavery. It simply says shall not exist. There are no qualifications on that. It is truly emancipatory language. And to enforce the 13th Amendment, a year later, Congress passes what's the first Civil Rights Act in American history. It's called the Civil Rights Act of 1866. And unlike the other Civil Rights Acts that are passed during this period, there's one passed in 1875, actually there's a couple passed in 1871, but the really important one in 1875. Those are all overturned. They either expire or they are overturned by the US Supreme Court. The US Supreme Court never overturns, never rules this one unconstitutional. I'll come back to that one later. It's kind of forgotten, and that's a shame, because it's terribly important. And then to give the act, so it's not just an act, but actually is put into the Constitution, and for other reasons as well, Congress creates the 14th Amendment, which has in its first clause this, which is language that I think most of us have heard many times. The first sentence is about citizenship and establishes, as I said, birth as the basis of citizenship formally in the Constitution. And that is something that, of course, we can talk about if you want to talk about ius soli. There it is. The other phrases are actually more invoked in US law than the citizenship one on a regular day-to-day basis. This idea of privileges and immunities, they're depicted, and this idea of equal protection of the laws. These are very important phrases in American law that I can speak to. But I want to spend just a moment going a little bit more deeply on the Civil Rights Act of 1866. This is an act, as I said, passed in part to enforce the 13th Amendment, in part is a reaction to what the southern states did after the Civil War, which was to effectively try to recreate slavery, and to do so by finding every loophole they could. And they pass what are known as the Black Codes, that are restrictive codes against free black people, that include such things as restricting their rights to contract, restricting their rights to travel, restricting their rights to bear arms. Now I come back to this other life I lead about firearms legislation. And that's terribly important because the right to bear arms and to belong to a militia is something that had been denied to blacks under slavery. It's been denied to free people of color under slavery. And it's a fact that the justice uses in Dred Scott, that denial of firearms carrying and black membership in militias. That's one of the facts that they use to say that blacks are not citizens. And that's a terribly important point on a side note to today, because thousands of supporters of gun rights are black Americans. And the reason for that, well, there are many reasons for that, but one historical reason that they invoke is that fact, that to deny anyone rights is to go back to a form of slavery where such gun-owning rights were denied to black people. Now that type of logic I can expand on if you wish, but that is a powerful logic. On the gun case that came before the Supreme Court early part of last year, the amicus briefs, these are briefs filed on behalf of the plaintiff, that is trying to overturn the New York gun law, included about 3 briefs from associations of black gun owners. The phrase black gun owners are in the name. The Civil Rights Act seeks to overturn this, and it does it with language that I think is remarkable. Again, this precedes the 14th Amendment, and it will lead to the 14th Amendment. I've highlighted a few things. I haven't said anything about indigenous populations, and so I thought I would highlight there now in case you have a question. So basically, Indians not taxed are excluded. What does that mean? So many of you know what that means, but that effectively, if you think about indigenous population as divided by law into 2 groups, those who have renounced affiliation to their tribe, and therefore, this is to use a modern term, tribal citizenship, and have, by treaty usually, become American citizens, okay, those are Indians taxed, and so they're covered by this. But those who have not renounced, they are Indians not taxed, they are not covered. Indian citizenship would then, was a contested issue then, and would continue to be contested. In 1965, this crucial year that John Torpy talked about yesterday, which is a year both when they lift certain immigration restrictions, it's the Voting Rights Act, it's also the year of Indian citizenship law. And so all these things happening at once. But now, jumping to this, here's the language that is lost to us today, right? That everyone, right, regardless of race, will have full and equal benefit. That's the only time this phrase appears in law. Full and equal, not just equal, full. Of what? What's the standard of the benefit? And then they give it. The standard is, as is enjoyed by white citizens. In other words, they invoke, if you will, the highest standard in this racial hierarchy, a white citizen. And they say that is the standard by which all will now be leveled. That is a remarkable piece of legislation. Now, that exact language no longer exists in the law, but the structure of the amendment still does. And that language of full and equal benefit and white citizens drops out when we get to the 14th Amendment. Just a little history of that. I also want to say, this becomes terribly important, that the word citizenship in the original version did not exist. It was just about civil rights or immunities among the inhabitants. Still full and equal benefit, no use of citizenship. The final version adds citizenship. Why? Well, I know the answer to that. For its exclusionary power. Because without citizenship, if you go with the first one, no discrimination means no discrimination of anyone. Citizenship was put there mainly by Western lawmakers who wanted to make sure that this law could not be used to give citizenship to those who were immigrating or had immigrated from China and were born in China. So this was about Chinese immigration. Citizenship was a way to make of exclusion of that population. Citizen is used not to include, but to exclude. And then, of course, the 14th Amendment, if you don't know, this is the most used amendment in all of constitutional law and has been since the early 20th century. I've already shown you this before, but now you see again how that language drops out. I can speak about this more if you wish. But again, this idea of the 14th Amendment. I show it to you now because then what happens is in the 35 years that follow, the US Supreme Court whittles away at this meaning and whittles away at the rights given. And that period sort of ends where I want to end today, which is a decision that was mentioned briefly yesterday by Brenda Stevenson, because her main talk, of course, was about a more modern period. She certainly knows a lot about this. But I want to end with Plessy v. Ferguson, which has remarkable relevance to where we're headed now. Now, Plessy v. Ferguson, let me just stop that for a second. I need to give some background for those of you who don't know. The color line, if you will, Jim Crow, exists even before the Civil War, but then it is institutionalized after the Civil War, and then it's given a legitimacy by the Supreme Court in Plessy. In the Plessy case, as we call it, this is the case that says, it comes out of New Orleans and deals with racially segregated rail cars. That is, you had to either ride in the black car or the white car. And I'm oversimplifying things. And the question is that against the 14th Amendment? Isn't that necessarily unequal treatment and a form of discrimination? And the court says, no, that separate does not mean unequal, effectively. That's the law of the land until 1954 with Brown versus Board of Education, which says separate is inherently unequal, right? So the Plessy case, this is the majority opinion that holds. I show it to you here just because it has this phrase, a badge of inferiority. The idea of a badge of inferiority, also known as a badge of servitude, this is an idea that has been bouncing around for decades. And really, in the Civil War and Reconstruction period, this notion of a badge, Lincoln calls it a band when he meets with African Americans, a group of free African Americans, to persuade them in 1862 that it's in their interest to lead their people out of the United States and to be colonized. That's generous. To emigrate, a subsidized emigration. I say it's generous. How can that be generous? Because colonization implies you get to have citizenship. Lincoln, when he makes this pitch for what he calls colonization, says, look, you're not going to have US citizenship. If you go to Haiti, they'll give you citizenship. If you go to Liberia, they'll give you citizenship. But those are black republics, they'll give you citizenship. But if you leave the country and go to where I'm thinking you might go, which is a place in what's now Panama when he gives this speech, I can't guarantee you'll have any citizenship. And he says, go where you may in the United States. If you stay here, you definitely won't get citizenship because go where you may. This is Lincoln. The ban is upon you. The ban is upon you. I would argue that notion of the ban is the same as a badge of servitude or badge of inferiority. And there it is in the Plessy case. And there also is the notion of natural affinities, which I would say is, again, this idea of association. The idea of people who naturally associate with one another. Natural affinity and a mutual appreciation, fellowship, brotherhood, fraternity. It is not, the only way to have citizenship is for that fellowship to organically happen, says the majority opinion. But it's the minority opinion that I really want to talk about. The minority opinion is what gets all the press today. And I will end with the minority opinion. It is this opinion issued by John Marshall Harlan, who says, look, our Constitution, there is no caste here. He's against the opinion. You're creating caste with these laws. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Our Constitution is colorblind. This phrase, colorblind, Constitution, this is where it comes from, the dissent in Harlan. Harlan's dissent in Plessy. And I bring it up here because today the United States Supreme Court has as its Chief Justice John Roberts, who has said on more than one occasion publicly outside of the court that he believes that the Harlan dissent is the most important statement that the Supreme Court has issued on race. He has said that in speeches he's made outside the court. And he has invoked it, at least in one case, dealing with voting rights while on the bench. And one of the things he has said is that what should have happened in terms of civil rights and citizenship in America, let me just focus on civil rights. Citizenship gets a little bit more complicated. Is not Brown v. Board, but we should have acknowledged that Plessy was decided wrongly. That is what eventually was decided. And if you decide that Plessy was decided wrongly, then what you then should do, obviously, is take the dissent and make that the law of the land. And this is what Chief Justice Roberts says. Therefore, logically, what we need is the law to say that the Constitution is colorblind. There should be no mention of race, white, black, race, any of these things in the law. That's the colorblind Constitution. And Roberts has said this. He controls the court more than any single person does. In many ways, that's good, but on this one, it's not. And so where is this going? I think we're going to hear a lot more about the colorblind Constitution. What is omitted from Harlan's opinion by Justice Roberts, and it is wittingly omitted, is what precedes immediately this part of the opinion by John Marshall Harlan. The white race deems itself to be the dominant race in this country, and so it is in prestige and achievements in education and wealth and in power. So I doubt not it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in view of the Constitution and the eye of the law, there is in this country no superior dominant ruling class of citizens. The letter of the law must be race neutral, must be colorblind. But in practice, right, race superiority will continue. In fact, those two things are mutually reinforcing and constitutive. One should not read this without also reading Gramsci, right, the hegemonic function of the law. Because if you've read Gramsci, you get this right away. Not that Roberts has read him, or Harlan, of course, and because Harlan precedes him. But this idea that the way to maintain power is to have a letter of the law, in this case, that is colorblind. And in this way, you can avoid problems. If you admit color into the Constitution, continuing on in Harlan's opinion, this is what happens. This is still Harlan. If you do that, right, you permit the seeds of race hate to be planted under the sanction of law, because then you acknowledge that race is a thing. And you thus, just by acknowledging it, you plant the seeds of race hate. So that is the logic. Erase the race line and race hate might disappear. But of course, that's only one piece of this, and again, quite Gramscian in its nature, I would argue. And so there we are today, and where we stand on the precipice today, if we are to go back to this, well, not go back, but to adopt the opinion that was never adopted of a colorblind constitution. And that, I think, is where we are headed. I could be wrong, and John Torpy may have things to say about this since you're working on this now. And if that happens, what kind of future do we hold? It is a future that in law would thus be about equal citizenship, I suppose, colorblind citizenship, I suppose, but it would be the fulfillment of the negative side of citizenship in all of its dread. And so I think I'll stop there.
I'm sure there are a lot of questions for Professor Vorenberg. John Torpy?
I have a question. That was terrific. But the question really is about the 13th Amendment, and it's the question of the exception clause. And I'd just be interested to hear your understanding, your interpretation, because as you suggested but didn't really flesh out, this has been used widely to explain essentially mass incarceration.
Right.
And the question, and that depends obviously in part on what you understand slavery to be, right? I mean, how you interpret that clause depends in part on what you mean by slavery, what slavery is.
Yes, and so I'm going to dodge the question a little bit by saying that Eric Foner's most recent book, which is called The Second Founding, right? And it's an investigation of each constitutional amendment and a kind of oversight. His small bit about the exception clause is, I think, the best thing there is that answers this question historically on sort of why it's there. And so I'll just point out that first. But I want to talk about this more popular notion which has the form of a kind of conspiracy theory, which is that it was put there as a kind to make sure that slavery still could exist, right? And of course, it did. It did not necessarily exist in the form of chattel slavery, but badges of inferiority, servitude, etc., exist in convict leasing, of course, and most visibly, and then, of course, in carceral state. And that's why it was put there. So that's a teleological way of seeing things, and I could engage with it and say, look, that's not quite right, blah, 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 but who really cares, right? The thing is that forms of slavery did continue. That is not the reason. There wasn't this kind of plot to put it there for that reason. There were insidious reasons to put it there. The most important person to understand as to why that particular phrase is there is Beccaria. And if you don't know why, that's understandable. I only figured this out with the help of an undergraduate a couple years ago. Beccaria, in his work about, of course, penal justice and so forth, is part of a number of Enlightenment thinkers, but he makes the most clear statement of all. He's writing, of course, against the death penalty, and he comes up with an argument to explain, well, okay, let's come up with a different kind of punishment so that we can get rid of the death penalty. And he says, let us say that the worst sort of punishment there is to be remanded into slavery. Now, he says that because he assumes that no enlightened society ever can remand a free person into slavery. So it's basically just the ultimate deterrent that can never possibly happen. Now, I'm oversimplifying things, and I can give you more cites to this. So Jefferson reads Beccaria, uses this phrase when he writes the Northwest Ordinance. The Northwest Ordinance, I could go into, is the first draft, 1784, Jefferson writes, is finalized in 1787. This has to do, among other things most relevant here, with how slavery is prohibited in the Northwest, which actually is what we would call the Midwest, Ohio, Wisconsin, and so forth. And of course, slavery wasn't prohibited there because of this involuntary servitude clause. Servitude, especially racialized servitude, continues in the Northwest because of that exception clause. But nonetheless, when they go to write the 13th Amendment, they use the language they've been using for decades, which is the language of the Northwest Ordinance. Any anti-slavery lawyer knew that phrase. And so when Charles Sumner proposes alternative language, which he invokes the French Revolution and talks about equal rights of all men, and he uses a phrase directly from the French Revolution. Fellow senators admire Sumner's convictions, they hate the man. And they say, and they also don't like the French Revolution, that's an American tradition. And so they say, quite literally, we don't want anything about the French Revolution in this Constitution. That language makes no sense in American context, so we're sticking with this language of the Northwest Ordinance. And that's my quick there. Did they intend that servitude would continue? I think they saw that it was absolutely possible, and they allowed that possibility. And so for this, they should be, they were deeply flawed, yes.
Thank you. Such a fascinating talk, and I was really curious about just doing a kind of a close reading of that Plessy thing, 'cause it said, if I remember write it down correctly, no caste here, our Constitution is colorblind. And it reminded me, first of all, it reminded me of this essay by Roland Barthes in Mythologies called Operation Margarine, in which you admit a little bit of evil, like margarine does, in order to distract you to get away with more evil, the long-term harm. Right? And here, there's an acknowledgement of the color blindness, but then there's a denial of caste. And I was curious how you would think about caste specifically in relation to Isabel Wilkerson's work that came out on caste as kind of this defining structural feature of American society.
Right, and that is a wonderful book. And this idea of caste. And I forget the scholar's name who's just begun publishing their work on American notion, what America is reading, right, in the subcontinent, right, in India, in caste. They're not reading it correctly, of course, but that's where they're getting the term, and they're also using terms like Hindu and they're using these terms wrongly. It's a fascinating story, right? How this word caste comes into the language, the legal language, and I can't trace that genealogy with any kind of justice. But all I can say is that it's relatively recent. That is, you don't find the word caste prior to really the 1860s in American law, but it was a wonderful word that people use. What you do find is the word class, but not the way we, right, not the economic way it's used. So in classes of citizens, that's a classic, what we call sort of Jacksonian democratic construct. There must be no classes. What that really means is no special privileges that attach to a group of people. It's not, and so what's happening here is a fusing of an old idea of class, which is the way we think of class, with a newer idea of caste, which they're misusing, and they're making this equivalent. So I can't say more than that, except to then say that by the point that the period that Wilkerson's writing about, which is somewhat later, early 20th century, caste has then become fully integrated into the language, and so important for the race line, because it's not until the 20th century that the race line becomes justified not only by law, but by social science, by intellectuals, where anti-miscegenation laws, as they're called, which are anti-race mixing laws, are now actually not just on the books, but said to be progressive. Right? These are seen as part of a modern system. And so we are modern cosmopolitans when we use this language, is sort of the idea of the white superior, the white superior caste.
So I've often thought about, well, kind of the dominant reading that I know of colorblind racism is that it emerges in the post-civil rights movement, the 1970s and 1980s, this kind of white racist retrenchment, this whole discourse of reverse racism, as an assault on an appropriation of Dr. King's words that were,
Right.
etc. But I'm kind of curious if, in some ways, and obviously there's a deeper genealogy to this colorblind racism that you track. But I'm curious about if you know of any kind of conscious appropriation of these kind of, this, like, going back, like these actors, like Ronald Reagan,
If I have to, I will.
Yeah, I mean, I was going to say something, but I was like, well, Reagan thought trees caused pollution, so, but those around him, the intellectual architects of his movement, if there was any kind of self-conscious appropriation of the Harlan, like, were people aware when they were?
Oh, absolutely. Yeah, and so in the Bakke case, which is the affirmative, that's the affirmative action case, as it's often called, the idea of color blindness is mentioned, and everyone knows that they're talking about Harlan. But you're absolutely right that the more immediate issue, right, is to appropriate the civil rights language against them. But of course, there's this notion that the further back in history you go, the more legitimate you are. Now, I don't, this idea of legitimacy in history, or history as legitimacy, which is something legal scholars write about a lot. And so they can then say, look, this isn't a backlash against King, right? This is deeply rooted, this colorblind tradition. And you can find, and then you can also find people not using the phrase colorblind, but you can find African-American activists in the North in the early Republic who are talking about, no caste, no class line here, no color line here. And so then they use that too, and they marshal that against this. So it's a misappropriation, of course, of what's being invoked. I would say it's actually an appropriate appropriation of Harlan in this way. But of course, they carefully excise the part that really reveals who Harlan is deliberately in order to invoke him as this kind of hero for racial progressivism. Yeah, they knew what they were doing, and they still do, right? Yeah. And all right, so
Any final questions?
May I ask just a very quick question about the declarations of the sailors? You showed us this fantastic source, really. I was struck by the people saying that they were citizens of the United States. So I was wondering whether there are examples also of people saying that they are citizens of the state. I mean, because there is this two-level citizenship in the United States, so I was
yes,
thinking.
and I did not go into that for time period, but absolutely. And in fact, so I showed you the first phrase of the 14th Amendment that says, you are citizens of the state and of the nation. But the idea is that your national citizenship is what matters, right? And so in constitutional history, 5 years later, the Supreme Court will make its first ruling to say, what does that actually mean? And they will insert back into the Constitution this notion that your citizenship in a state matters as much, if not more, than your national citizenship. So in answer to your question, what I have not shown you, because I didn't want to complicate things even more, were certain depositions that I have where sailors say, I am a citizen of Virginia, right? That's, I think, what you're asking, right? I was born in North Carolina, but I've lived in Virginia for 20 years. I'm a citizen of Virginia. And they never mention the United States, and they never mention the Confederate States of America. So I found those too. Or they say, I'm a citizen of Virginia, I owe allegiance to the Confederate States, or I owe allegiance to the United States. And citizenship, of course, in its European context, its ancient context, is a local definition. It's rooted in the idea of a city. And so that is also true in the United States, but it is subtle. It is much more subtle. It's harder to identify as such. But the irony now, not ironic, it's tragic, is that state citizenship, again, has reemerged as this idea where the justices there are two justices who repeatedly on the Supreme Court say, the sovereign state of Ohio, the sovereign state. The idea of a sovereign state was supposed to be obliterated by the victory of the United States in the American Civil War and by the 14th Amendment. And for them to bring in sovereign statehood, that isn't a distortion. That's a regression to saying as if the Civil War and emancipation, basically, we don't need to think about them. Thank you.
Thank you. Thank you for a fantastic closing keynote. And now they've been waiting for us upstairs to have a drink, and then conference participants will meet at the front gate at 8:05 to go to dinner. We're eating off campus tonight. But let's go have a drink. And let's give ourselves a final round of applause.